Vice Chair Duncan, can you hear us?
I can.
Okay. You have the parties and your panel. We also have Allison with us, so we're ready to go live.
And I believe Lou Martin is with us also.
Yes.
Zach and Tim. Yes, sir, and we also have Tim Hogemeyer and Zach Paget.
All right, very good. Well, we'll go around with the round of introductions in a moment. Are we ready to go with streaming, et cetera?
Yes, sir.
Very good. Well, I call this panel hearing of the Board of Education to order, State Board of Education to order. Today is Tuesday, December 5th. It is 3 p.m. We're here today to hear an appeal by Maggie's Outreach from a decision by the North Carolina Department of Public Instruction's Office of Federal Program to revoke the award of 21st Century After-School Programs grants to Maggie's Outreach. My name is Alan Duncan. I serve as Vice Chair of the State Board of Education, and today I'll be serving as Chair of the panel hearing for this occasion. The other panel members present to hear the appeal today are my State Board colleagues, Mr. John Blackburn and Mr. Wendell Hall. All three of us have been duly appointed by the Chairman of the State Board of Education to this panel to hear this matter on behalf of the full State Board of Education and then to make a recommended decision to that body. I want to welcome those listening to the proceedings today. Panel members, you are reminded that it is our duty to avoid conflicts of interest and the appearance of conflicts of interest as we handle the work of the State Board of Education. I want to pause for a moment now. I think there is at least one line that's open and we're hearing what's being said. So if everyone will be careful to mute your feed unless you're speaking. Specifically, it looks like the SBE audio is open.
Vice Chair, we need that to remain open so that it will carry to the live stream.
All right, well, if that's the only one open, we're getting a decent amount of feedback, so I think caution, it should be as quiet as possible, will be most helpful.
Yes, sir.
Thank you so much. So back to where I was, I want to ask each board member if they're aware of any conflict that might disqualify them from hearing this matter, or are aware of anything else that would keep them from fairly and impartially deciding this appeal. We are here to consider the recommended decision of the independent hearing officer appointed to hear and render a decision in this matter. Mr. Blackburn, let me ask you, do you have any conflicts of interest in this matter?
Vice Chair Duncan, I have no conflicts.
And can you be fair and impartial in this matter?
Yes, sir, I can.
Mr. Hall, let me ask you, do you have any conflicts of interest in this matter?
No, I do not, Mr. Chairman.
And can you be fair and impartial in this matter?
Yes, I can.
And I will state for the record, I do not have any conflicts of interest and that I can be fair and impartial in this matter. Next, I would like to take a few minutes to share the procedure for the hearing today. Each side will be given up to 30 minutes to present its case and may reserve up to 5 minutes of that 30-minute time period for rebuttal following the main presentation. Allison Schaefer will be our timekeeper. The panel members may ask questions of the parties either during or after the presentations. At the conclusion of the presentations, the panel will deliberate and vote on a recommended decision to be presented to the full State Board of Education at its December 7, 2023 meeting. At that December 7th meeting, the State Board of Education will make a final decision on this matter. At this point, I'd like to ask those present on behalf of the parties and other representatives to introduce themselves. And I will start with the folks who are here to represent Maggie's Outreach.
Yes, good afternoon. My name is Jose Coker, and I'm here with my client, Ms. Ophelia Ray.
Good afternoon and welcome, Mr. Coker and Ms. Ray. All right, from the Department of Public Instruction, the presenting representatives, can you please introduce yourselves?
Thank you, Chairman. My name is Zach Paget. I'm from the Attorney General's office, and I'll be presenting for DPI this afternoon.
Welcome. And anyone else from the department who is present with you?
I believe Susan Brigman is on here as well. I will be doing most of the presentation. She's on there in case the board has any specific questions related to a couple meetings, but otherwise I think I'll likely be talking for the entirety.
All right, thank you.
Thank you.
And now on behalf of the department and the state board, Ms. Schaefer has already been identified, but I'll let her identify herself and any others who are on the call.
I serve as, this is Allison Schaefer. I serve as counsel to the State Board of Education, and I am representing the panel today and serving as counsel to the panel.
Thank you. Anyone else from the department?
This is Tim Hogemeyer. I am observing here, Deputy General Counsel, and just here to observe the proceeding.
Very good, thank you. Anyone else?
My name is Lou Martin. I also work with the State Board of Education.
All right, thank you. And
Vice Chair Duncan, I think we have a few from my staff that are also present, as well as our Senior Director for Federal Programs, Alex Charles. But the other folks that you see on the call work directly with 21st Century. There's Ashton Moss, Monica Pask, Melba Strickland, and Hawana Locklear.
all right, thank you very much for those introductions. So have we got, is there anyone else who has not had a chance to introduce themselves who's on the call?
This is Rupen Fafaria, I'm Director of Board Operations and Policy for the State Board.
Very good. Thank you for organizing this. All right, before we start, I have a couple of, and I want to solicit input from both sides to see if we can just agree on something basic that's not quite as clear from the record as would be ideal. And the first question is the cohort status for 14, 15, and 16. What is the timing for each of those? That is, can we agree upon there's a date where the timing for each of those cohorts ends? And can we have that, please? I'll call on Maggie's outreach representative first, if you, Mr. Coker.
Thank you, Chair. I believe the dates are as follows. I think June 9th, 2020, August 12th, 2021, and July 7th, 2022.
And what is the end date for each of the actual grants?
Hi, good evening. Thank you, Chair. This is Ms. Ray. The cohort 14 sunset in September this past year. Cohort 15, we're in year 2, and it's supposed to sunset in September of 24. Cohort 16, we're in year 2, and it's supposed to sunset, I believe, in 25.
Would that be September of 25, Ms. Ray?
Yes, sir.
All right, thank you. That's helpful information for us. It was not completely clear. There's the other question that just for clarity, and let me first ask, does the department agree with those timeframes that were provided? Mr. Patch?
Yes, sir. I'm absolutely for the sunset for 14 and the years for 15 and 16. The exact days I'm not sure, but the month and date sound about right. So roughly, yes, sir.
They're correct. They're correct, Vice Chair. September 30th for each of those.
All right, very good. Thank you. The second question I have is, what is the status of the two programs that did not sunset in September of 2023 in light of the August 2nd letter proposing termination on August 31, 2023, and then the subsequent appeal that has taken place? What is the present status of those two programs or those two cohort years?
They are currently working on their continuation applications for both cohort 15 and cohort 16.
All right, and by continuing to work on their continuation applications, does that mean the programs are actually in progress still?
That I can't speak to. I know that they are working right now with their program administrator and fiscal monitor to complete their budget and their applications. They've been sent back for corrections. So I would have to defer to Ms. Ray. I'm not sure if they're operating quite yet, or I'll let her speak to that.
Thank you. Ms. Ray, could you let us know, are they in operation right now?
They are in full operation. We started in enrollment, and the program began on October 2nd of this school year.
Thank you. All right, that's helpful information. If everyone can agree to that, that gives us, gives the panel the status in terms of where things are. So I appreciate that. But at this point, we undoubtedly may have some additional questions. We will ask questions potentially while you're presenting, which could impact your 30 minutes. But we will try to reserve some questions at the end as best we can. But at this point, I'm going to ask Mr. Padgett to go first and make his presentation. And at that point, we would then have Mr. Coker for you to proceed with your presentation. So Mr. Padgett, let me turn to you and ask if you would please proceed and make your presentation for us. And one thing I should tell you, we have read your briefs beforehand, so that you both know that we have read them.
Okay. Thanks, Chairman, members of the panel. Again, my name is Zach Padgett, and I'm here today to ask this panel to recommend the State Board of Education that they reject the recommended decision by the hearing officer and uphold NCDPI's Office of Federal Programs decision to terminate Maggie's Outreach 21st Century Community Learning Center grant, which I'm just going to call the 21st Century Grant. In support of this contention, as the chairman noted, DPI submitted a written summary of its position along with 12 exhibits. My plan today is simply to summarize that argument and answer any questions that the panel may have. And I would like to reserve the 5 minutes to the extent that I can for rebuttal. As the panel is aware, Maggie's Outreach received 3 grants from DPI, which are being called Cohort 14, 15, and 16 under the 21st Century Grant Program. The purpose of the 21st Century Grant Program, of which DPI is a pass-through entity, is to help fund community learning centers that provide academic enrichment opportunities for children outside normal school hours, such as before and after school, over the weekends and during the summer. In order to ensure that programs that receive those funds are effectively serving students, DPI developed its 21st Century Grant Guidance, which we attach as Exhibit 3. This document is provided to all subgrantees, such as Maggie's Outreach, who sign assurances that they have, sorry, I thought I heard somebody, that they have read, thoroughly understood, and will abide by these requirements. Maggie's Outreach did this for each of their cohorts, and those were attached as DPI Exhibits 21, 22, and 23. These grant guidance, which I referenced earlier, include multiple requirements to which these programs must comply. It also lists grounds for termination. One of these grounds, which is especially pertinent here, is that each cohort must maintain an average daily attendance of 70%. In its submission, DPI provided this panel with a timeline of pertinent events relating to its decision to terminate the grants to Maggie's Outreach. The most important event listed in that synopsis is the termination letter that was sent on August 2nd. That's the operative document that we're talking about here today. And that letter listed 2 reasons for termination: low average daily attendance and a failure to provide a safe and effective learning environment. Now, despite numerous opportunities, Maggie's Outreach has not refuted either of those grounds for termination, specifically the lack of average daily attendance, which I want to talk to first. As mentioned previously, pursuant to the guidelines that Maggie's had agreed to, each cohort was required to have an average daily attendance of 70% in each specific cohort. Maggie's Outreach did not satisfy this requirement. Now, just to make this clear, these aren't DPI's numbers. These are numbers we received from Maggie's Outreach informing us of their average daily attendance, in each of these cohorts. According to their numbers, their average daily attendance was as follows. Cohort 14, the ADA average daily attendance was 50.5% of 86 enrolled students. Cohort 15 was 50.4% of 103 enrolled students. And cohort 16, which I want to focus on for a minute, the ADA was less than 2%. And I'll say that number actually doesn't even quite do that justice, because if you look, and what we included in our submission was the day-to-day attendance of each of those cohorts. And if you look at 16, we said that they had an average daily attendance of 2, but that's because we had to round up, because you can't have 1.6 students. But if you look at every day in January, that cohort served 1 student. If you look at every day in February, they served 1 student. If you look at the first couple days of March, they served 1 student. They then increased to 2 students. This is a cohort that was supposed to receive $400,000 in public funds. And at most, they served 2 students. And it wasn't as though they had a high number of enrolled students that simply didn't come. They only had 5 students that were enrolled, which in addition to the average daily attendance brings in another issue because each cohort is required to have 50 enrolled students. They had 1/10 that number, and on many days they were serving simply 1 student. They don't have a counter to these numbers as these are their numbers. They accepted these guidelines, they accepted this money, these public funds, and agreed to abide by this guidance. And pursuant to what they provided to DPI, they simply did not. That's irrefutable. Instead, in both for the hearing officer and in their submission day, they've attempted, I would say, to muddle some of these issues, which has led to some confusion. In our we submitted to the committee or the panel, excuse me, we addressed many of these issues, but I want to highlight a couple of them. First, DPI, unlike contention from the other side, did provide technical assistance regarding average daily attendance to Maggie's outreach in December of 2022 and February 2023. And if the committee has questions about this, these meetings, Susan Brigman, who's already spoken, is on here today to answer those questions. Despite, and I'll also note that we included an email thread regarding one of those meetings in February, which is attached as Exhibit 25. Contrary to opposing sides' contention, there is no requirement that this technical assistance be in writing. Oftentimes it would not be. It would simply be done in meetings in which they would make the grantees, sub-grantees aware of the issues with average daily attendance, which is exactly what occurred in this situation. Additionally, unlike previous contentions, there is no requirement that a sub-grantee receive a written warning prior to the termination of a grant.
Would you mind pausing on that point for a question?
Yes, sir.
I appreciate you pointing out that there's no requirement, but you do agree there are due process considerations that attach to any attempted termination of this program, the way it's been set up?
I would broadly agree with that. Yes, sir. I think I guess I would need a little more definition of what we're saying by due process requirements. I think receiving a hearing in front of an impartial hearing officer and then as well in front of this panel would satisfy that. But what particular due process concerns would you have, Mr. Chairman?
Well, the right to a hearing generally implicates due process concerns, and I think you agree that there's a right to a hearing. There's been a officer hearing. It's always subject to ultimately to the board final decision.
Yes, sir.
So my question is, would you not agree that it would be a much better process to have warnings in writing when there are due process considerations at play?
Well, sir, I guess potentially, but I think it's whether or not it perhaps is a best practice. I don't think it implicated any process issues in this situation to make these individuals aware that they were having issues with their average daily attendance based on their own records, work with them via multiple meetings to satisfy those issues. And if the, if the sub-grantee continued to basically refuse to make those changes, I think DPI was well within both the written policy and also any due process concerns to terminate that grant. They are trying to make sure that these particular individuals are properly using hundreds of thousands of dollars of public funds.
Continue. Thank you.
Thank you, sir. The second thing I would like to clarify is the difference. I think it was made both in the submission and also previously between regular attendees and also average daily attendance. Regular attendees is how DPI basically uses to determine whether or not a sub-grantee will receive the next installment of these grants. All of the grantees receive an initial installment when they provide the fiscal year budget and other related documents. They then receive the second if they can show they've received 50% of their enrollment goal and that they have regular attendees and that students are attending 45 hours in order to constitute somebody for that. For the third one, they must show that they've reached 75% of their enrollment goal, and the students, in order to count as regular attendee, must attend 90 hours. This is a different qualification than average daily attendance. Average daily attendance is simply calculated based on the total number of kids that attend the program, each cohort on average every day. And that is what must be required to be 70%. In this case, cohorts 14 and 15, while closer, were still 20% below what was required, what Maggie's outreach agreed that they would comply with. Each was around 50% rather than 70. And then cohort 16, which we discussed earlier, was 2%, less than 2%, was one student on many days. Neither of these, I think, was our contention, were anywhere close to what was required and agreed to by Maggie's outreach. And based on the actions taken by DPI, they were well within both the guidelines and what it was granted to them by terminating. I would like to note that that in and of itself was sufficient to terminate each of these grants. In addition to those serious issues, DPI also noted some safety concerns during their comprehensive review of Maggie's outreach, which was listed a little additionally in the previous letter in March, but also noted here specifically related to background checks of employees of Maggie's outreach, and that many of them did not have background checks or were not done prior to them beginning to work with children, which was a concern for DPI, which was why that safety concern was listed. However, even if the panel finds that that's not sufficient, I would note that, again, average daily attendance or lack thereof in this case was more than sufficient to terminate these grants.
So could I pause you there and ask a couple questions?
Yes, sir, of course.
So the first question about the attendance, I recognize from the materials that have been presented that 70% was set out as the goal to reach 70% at least as a minimum. But there's also some language in there about proportionality, and which is referred to in the brief that's been submitted on behalf of Maggie's outreach. And if you're, in the essence of which is that the department is to help if there's short of that to get to that 70%, there's some proportional approach about how you think about it or get there. Could you comment on the response of the department to those concerns that are expressed in the brief that's been submitted by Maggie's outreach?
Well, I think at a certain extent, when they've already met with Maggie's outreach multiple times and made them aware of these issues, and then being DPI, federal programs, continues to see cohorts, despite these meetings, despite these attempts to rectify those issues, they continue to receive numbers from Maggie's outreach, which are well below that required number, specifically for cohort 16, which is 48 children below what was required. I think at a certain point, they have to also understand that they have to balance that while they hope, then again, it's much easier for DPI for these programs to remain open because they've gone through this whole process to provide them with these funds. They would prefer them to remain open. But at a certain time, they also are being good stewards of that money. And if you're considering, despite your best efforts, consistently receiving reports from a subgrantee that they simply don't have any kids coming to a program, at a certain point, I think it's well within inappropriate for them to terminate those grants.
Do you have any, is there any consistent approach or articulated policy about how this proportionality aspect of the guidance is actually dealt with on a day-to-day basis by the department? Are there any further guidelines beyond what we've been presented with?
Can I respectfully, when you say proportionality, just can I have a little clarification what you mean by that?
Well, I'm really asking you that question because that's the word that's used.
I believe whatever is within the guidance or whatever has been submitted would be basically, and I would defer to Susan here, but I believe that we provided whatever guidance is used by the department to recognize and make those decisions.
All right, well, let me ask then the other question I had while you were here. Was there any, the assertion is made that there's no evidence in the record about safety concerns, which were listed in the March letter, and then again in the August letter. I see in your brief you set out concerns about criminal background checks appeared to be the essence of the concern expressed. Is there anything that was presented in the record of this hearing about that safety concern or was presented to Maggie's outreach about it that's in writing?
I believe it was referenced during the hearing. When you say, I believe it was referenced during the hearing from the hearing officer by my colleague Lizzie Jenkins. But I don't believe. I think the only thing in writing was in the August 2nd letter. It's just like safety concerns. It doesn't specifically say background checks. I do not believe.
Okay, and in that's the termination letter, so that.
Yes, sir.
That wouldn't serve as notice that that was a concern. I think you would agree with that.
Yes, sir.
Okay, all
Vice
right.
Chair Duncan, if I could clarify something for you. The
Please.
background check issues were addressed in their CPMR report, which is based on their monitoring that was conducted. All of the information about the background checks, with it being a safety concern, were documented in that report.
All right, thank you for that information. Please proceed.
Well, respectfully, sir, that concludes what the presentation I had for the panel. I would ask again, just based on what we've submitted along with the exhibits, what we've argued today, that DPI was well within its rights to terminate these grants, and we would ask for you to reject the recommended decision from the hearing officer and uphold DPI's decision to terminate all 3 grants to Maggie's Outreach. I'm happy to answer any additional questions you have, sir.
Thank you. Let me ask my colleagues, Mr. Hall, Mr. Blackburn, if you have any questions at this point.
No question.
Mr. Hall?
Yes, thank you, Mr. Chairman. I want to go back to the support given to Maggie Outreach with this average daily membership being so low. Specifically, what was done to help them with this area, because this is the main area, if I'm hearing correctly, this low ADM. Like this cohort 16, less than 2%. What was offered to them to help them increase these numbers, or if anything?
Well, I do know there were at least two separate meetings with them regarding that. And in terms of specifics of those meetings, if Susan's on, I would defer to her for that.
Yeah, I was going to ask her. Thank you.
Hi. Yes, sir. In addition to the 2 individual sessions that were provided to the subrecipient, we have offered multiple sessions on ADA. One particular was in November of 2022, in which Anita Harris, who is our data compliance specialist, she completed that training on ADA and how it should be reviewed in the 21 DC attendance system. And that training was left in the resources within 21 DC and in our CCIP homepage for grantees to refer to at any time. And after the one in November of 2022, we have offered multiple TA sessions for all of our subgrantees regarding ADA and how to increase attendance. I'm not sure if a representative from Maggie's Outreach attended all of those trainings, but most of the time I can say that they are on our TA sessions and our statewide meetings. They have really good attendance at our meetings.
So could one say then that Maggie Outreach was receptive to the info that was presented, the training?
For their individual training?
Yes, oh, yes. What have we offered?
They recognized that there was an issue.
But they were receptive to it.
Yes.
Okay, all right. Thank you, Mr. Chairman.
Thank you. And I have one last question, at least for now. And I think, Mr. Patch, I probably should address this to you. There's a letter dated May 17th, 2023 to Ms. Ray from Dr. Townsend. And in your brief, you characterized as a gesture of good faith, NCDPI allowed Maggie's Outreach to continue to use the ERACA system and issued a letter on May 17, 2023, indicating that the outstanding programmatic findings of the CPMR had been resolved. So this letter does not address Maggie's Outreach's continued failure to meet NCDPI's ADA requirements. The letter itself says, and this is from the May 17th letter, the Maggie's Outreach 21st Century Community Learning Center program has successfully met all federal and state statutory compliance requirements related to the comprehensive program monitoring review, which was referred to just a moment ago, conducted by the North Carolina Department of Public Instruction on January 11, 2023. So I am struggling to see how that letter when it says this letter does not address Maggie's outreach continued failure to meet NCDPI's ADA requirements, it says it met all the federal and state statutory compliance requirements and that were related to the comprehensive program monitoring review. So do you have any explanation for that letter and how we should be trying to understand that letter other than what the language of the letter says?
Sure. I'd have a couple statements, Your Honor. Now you're on. I apologize. That's old habit. I would say that initially that letter was meant during the term when both parties were attempting to negotiate a settlement. And I believe it was done in that vein in order to try and have a good faith effort on our part. However, I would note that the ADA, the CPMR, which is referenced in that letter, occurred on January 11th. And the ADA issues predated any CPMR, which, as Ms. Brigman noted before, the first meeting that they had with Maggie's Outreach regarding their low attendance was in December, which predated the CPMR. The CPMR was a comprehensive monitoring review that was done of the program in January, which was in addition to fiscal issues that were also noticed when they did a review. And that letter simply states that what the CPMR, which was done on January 11th, and which I believe is a part of the record, that the issues noted with the programmatic aspects of the different subgrantees and cohorts had been resolved. That doesn't reference the ADA, which both predated that CPMR and continued throughout the spring and after the May 17th letter.
All right. Well, thank you for that response.
Yes, sir. Thank you.
Any other questions, Mr. Blackburn or Mr. Hall?
No, sir.
All right. Thank
No,
you.
sir.
I think at this point, you've reserved at least 5 minutes, and if not longer, Mr. Paget. I'm sure Ms. Schaefer can fill us in on the exact time if needed.
Thank you.
Mr. Coker, I'm sorry, what'd you say?
Mr. Paget took 15 minutes, so there was 15 minutes, so he has at least 5 for his rebuttal.
Okay, thank you. All right, Mr. Coker, we will now turn to you for your presentation.
Thank you, Chair. I had a plan initially, but based on some of the...
Mr. Coker, I'm having a little trouble hearing you.
Can you hear me now?
Yes, much better. Thank you, sir.
Yeah, what I was saying was I appreciate it. I said I had a plan of, presenting certain facts, but I don't want to reiterate some of the things that Mr. Paget already touched on. But what I would say coming out of the gate here is that Maggie's Outreach would ask that this hearing, this panel, of course, affirm the decision of the hearing officer that heard this matter, as Mr. Paget said, through due process, that was not biased, heard facts that were presented by both sides and facts that were omitted or not present, and made a determination based on everything presented to him that the state, the NCDPI, failed to follow its rules and did not have basis to terminate the programs in this particular event. What I would say is that what is important here is several things, and I'm just kind of thinking back as to some of the points Mr. Paget made. The first thing I would say is that what baffles me is the interpretation of the May 17th letter. The May 17th letter speaks for itself. We received that letter, the cold record of that letter on May 17th, and it specifically says what it says. It's not up to interpretation after the hearing in this case now to determine that the NCDPI had some other intent. And I will tell you, and I believe Mr. Hogemeyer is on the line also, that letter was not sent as part of any type of settlement. That letter was sent by NCDPI because Maggie's Outreach had submitted and presented all the information that was required based on the CPMR and had showed compliance. What I would say also is that it goes to show you in this case just how jackleg this whole case was, because in January, when the state went out to complete its audit of Maggie's outreach, the monitoring, they sought certain information, and Maggie's outreach complied. They presented the information in a timely manner and specifically requested technical assistance as required by Section 8C of the grant guidance, which says program administrators will notify subgrantees whose ADA is below 70% of their targeted enrollment goal. The purpose of this notification is to provide an early warning as well as supportive and strategies to improve attendance. After conducting the second installment attendance analysis, if a grantee has an ADA below 70% of their current enrollment number, the subgrantee will be provided technical assistance to create an action plan detailing how they will increase the ADA. And it goes on. Now, this is the state's guideline and what the state was using to determine whether or not there was a basis to terminate. The state failed to comply with those rules and regulations, and yet now they want to, ignore those specific requirements and attempt to now terminate the program without themselves complying with the rules. The guidelines specifically say what needs to be done, and the record in this case shows that Maggie's outreach was not provided that type of technical assistance. Notwithstanding, Maggie's outreach did comply with cohort 14 and 15 based on the information that was presented at the hearing and in its brief. What is also important is that Maggie's outreach could not comply with cohort 16 at the time because its funding was suspended and its program was not able to move forward because Maggie's was attempting to work through the issues with the state, but the state would not respond and provide the information that they needed. And that's also in the record. And then what's also concerning is the fact that the state has now attempted again to rehash safety concerns, which are non-existent. You cannot manufacture safety issues when you have no proof to support it. The record in this case clearly shows that the state alleged certain safety concerns. They had ample opportunity to present evidence to substantiate those or corroborate those claims, and they did not. And yet they still continue to try to muddy the waters by attempting to create an issue that doesn't exist. And it's kind of hard to justify or defend something when there's no proof that it ever occurred or didn't occur. But what we can show is that background checks were pulled, they were provided to the state. The situations where the state tried to identify a matter where there was an argument never existed. And so what is interesting is that, as the hearing officer said in his recommended decision, paragraph 55, he said, there is no factually substantiation in the record. Everything regarding the safety and effective learning environments is factually unsubstantiated in the record. So here we are again, the state is trying to re-argue something that they haven't been able to prove from day one. And so therefore, as the hearing officer properly concluded, the safety issue should not be any basis for consideration for termination. Now, going to the other subject matters in this case, more importantly, the cohorts 14, 15, and 16, again, you have to look at the chronology in this case, which has been outlined in the synopsis and in the brief. So Maggie's outreach never had a history of any adverse action being taken against it until this situation occurred. Again, in January 5th of 2023, the state came in and said, we're going to do a monitoring. It occurred on January 11th. At that point, on January 13th, the state cut off the funding to Maggie's Outreach. 2 days after the monitoring had occurred, they come out and cut off the funding, despite what we just went over with respect to Section 8C of the grant guidance policy that said, these are the things that the state should do in order to assist its programs in being successful prior to taking action, such as suspending, terminating, or any other adverse action against an operator such as Maggie's Outreach. The state did not do that. Instead, 2 days after the monitoring, they went out and cut off the funding. They cut off everything. On March 20th, Maggie's Outreach submitted its response to the
February 7th.
Yeah, on February 7th, I'm sorry, Maggie's Outreach had responded to the NCDPI's report. And again, Maggie's Outreach requested technical training. Now, Mr. Paget says, well, you know, it's not necessarily a requirement that's in writing or that, you know, that we have to do this, but then where is it? What are the rules of engagement? What are the requirements that you're going to use in this particular case to say, we're going to terminate you based on something you haven't done when the state is not even clear as to what is required to be done? But what I can tell you here in this record is that the hearing officer that the state selected to hear this matter, who is supposed to be not biased, found favorably for Maggie's Outreach based on the evidence and the allegations that the state presented in this case. And what I would go on further to say in this particular matter is that you have the termination letter from the state from March 29th that listed 3 bases for the termination. Then you have what later transpires to be the May 17th letter, which here we are, you know, several months later, a hearing later, and we're getting a different interpretation of what the May 17th letter meant. Well, Maggie's Outreach relied on what the letter said. And if the state is not clear in what it's saying to its providers or its operators, then that's on the state, and this provider should not be penalized for that. But what I would say is that Maggie's Outreach complied, and they had submitted everything to the state that was required. And so it is believable, based on the letter, that they were in full compliance with all of the terms and the conditions that were required to be met in order for them to continue to operate. Then we have the August 2nd letter that then is produced by the state that only has 2 issues presented, but again, is unclear, as the hearing officer pointed out, as to safety issues. Notwithstanding, Maggie's Outreach properly addressed that matter, and then this matter came to an end in the hearing. But what I would say is that with respect to the policies of the state and the cohorts that are required here to have been properly conducted, with respect to 14 and 15, it's important to note that, you know, Mr. Paget points out that the information that was provided to the state came from Maggie's Outreach. It did, but you have to look at the time of that data. And as we pointed out in our brief, that information that you are looking at is for a limited period, not for the entire time. And so that's why the numbers are skewed in the way that they are. But the projections would have shown that Maggie's Outreach was on track to be in compliance with it. And so what we would also point out is that Maggie's outreach when it came to, I think it was cohort 16, that when they realized that there was an issue based on the fact that the funding was not available for them to operate the way that they needed to be able to have the number of enrollments, they resubmitted the reduction in lieu of termination to the state. They had a reduction of $268,000 of the $400,000 allotment that they had. They took that action because they're not in it to get something that they haven't earned or deserved. So they made sure to give that money back. And so what I would say here is that there is clear, cogent, and convincing evidence that was presented at the hearing that displayed and demonstrated that there was no basis for the action taken by the state based on the facts in this case. And as the hearing officer, I believe, properly identified, there were other actions that the state should have considered and other actions the state should have taken prior to going to the final step of seeking immediate termination. And so what we would ask is that this body adopt the decision of the hearing officer in this particular case and affirm the recommendation so that Maggie's can continue to operate with respect to the cohorts that are in current operation. And then with respect to cohort 16, I believe we had put in what we had asked that the state consider with respect to allowing it to continue to operate under monitoring. And so with that being said, Chair, I would pause for any questions and reserve any time I have left.
All right, thank you. Mr. Blackburn, Mr. Hall, questions for Mr. Coker?
I don't have any, Mr. Chairman.
Mr. Blackburn?
Yes, how many students are you currently serving under the cohorts you have?
Currently under cohort 15, we have currently 62 students enrolled. The new track this year states that we cannot put those children in the system until they have reached the 45 hours. So we do have in our district 62 of the 80 already enrolled. And cohort 16, we have, I believe there's 20 of the 25 required leading to the 50 that are currently enrolled. And we have, if you may, those are the enrollment numbers. I'll wait to respond.
Thank you.
Any other questions? Mr. Blackburn?
No other questions. Thank you.
All right, so let me get a little clarity, if I could, on cohort 14. Cohort 14 is completed now, correct?
Yes.
Yes.
All right, and is there any issue remaining about cohort 14 about which the state board would have to have a finding or ruling?
Are you proposing that question to us, sir?
Yes.
Say that again, Chair? Are there
any issues that still exist from cohort 14, given that it's now over, it's been completed? Is there anything issue for the state board to have to decide about cohort 14, which has completed its term?
Well, I would just say, and I'll let Ms. Ray also chime in, but from the legal aspect that there was grounds to terminate, I mean, I want to make sure that I would ask that this panel consider the recommendation of the hearing officer with respect to its finding as to cohort 14. But what were you going to say, Ms. Ray?
I wanted to include that cohort 14, after receiving the May 17th letter, we complied with all of the DPI's policy and were able to upload the data that had been shut down. We were not able to put any additional data in the system from January until we received the May 17th letter. And there we were able to put in, we had 24 hours. So at that time, cohort 14 also had a reduction in its last quarter allotment. And so that $400,000 were not fully granted for year 3 of cohort 14 as well. So as Attorney Jose just mentioned, moving that language that it was terminated, we met and complied totally to everything that was required. But the end results was that the enrollments or the ADA did not allow us to receive the last $132,000. So that cohort was also reduced already and has sunset, and we're able to move forward with that as well, cohort. So it is sunset. That is what I can say to you today.
And it was a reduction as it was sunsetting. Was that reduction, I think you mentioned $132,000, was that reduction in proportionality to the number of students it was short in terms of ADA?
It was according to attendance. It was, to my knowledge, it was not ADA. It was considered enrollment of not achieving the 90 hours by the end of the program year. And that the number of students that should have received 90 hours to be eligible for the full allotment.
All right. So I guess what I'm trying to bring to a head, just to ask, is you don't have any remaining position with respect to that cohort. That is cohort 14. The only thing I've heard you say is you'd like it not to be called determination, but in terms of any other issue, there's no other issue that remains about that. Is that fair?
We're ready to move forward. No, we don't have any more issues.
Let me ask DPI, is there any remaining issue from DPI's perspective with respect to cohort 14, or has that been completed and we can talk about cohorts 15 and 16?
I think the main focus for DPI would be on cohorts 15 and 16.
All right, thank you. So let's then turn to cohort 15, which at present, if I'm reading it right, the attendance numbers are around 52%, short of the 70%. Is that an accurate actual representation, or is it something different than that?
I'm sorry.
Go ahead.
I have my my manager here who can better explain. However, we met all of the requirements for cohort 15, and that is why, according to DPI, we were allowed to be eligible for our funding. We was to serve 80 students, and 70% had to have the 45 hours, the 90 hours by April 17th. At the end, once we were able to put all our data in, they saw that we didn't meet those requirements, and the funding was released to us. Those were the requirements. Typically, ADA is something we discuss at the end of the program year, not in January, but this time it came in January. So accordingly, we were given, according to meeting those compliance, we were able to demonstrate the full enrollment, the full meeting of the requirements for 15. And at this present time, we're told that we were fully funded because we met all requirements for cohort 15. And so I don't know that there was still an issue with cohort 15.
Well, what are the numbers for cohort 15 right now? That is in the fall of 2023.
The numbers this year, we were in year 3 of the same grant, which we were scheduled to serve for the program year, 80 students. Of that 80 students, we had to enroll and have at least 40 students participating with 45 hours or more. Again, ADA is something that comes into play at the end of the program year, not during the middle.
All right, so let me now turn to DPI and ask the questions. From your standpoint, from DPI standpoint, is there an issue about complying with the ADA requirements for cohort 15 as during this year, which is the final year of cohort 15?
Yes, sir. Absolutely. I would know that they haven't uploaded these numbers, which they are stating here today, have not been uploaded to the database with DPI. So there's no way for us to verify those numbers So yes, we have significant concerns about 15, and
Do they
I'd say on 16, but I'll wait.
Does Maggie's outreach, I'm going to ask about 16. I'll give me a second to get there. Let's stick with 15 for a minute. Does Maggie's outreach have access to upload this data into DPI's system?
We do have the data to upload. This year, DPI has instructed its sub-grantees to not upload individuals who have not met their 45 hours. So we have had to create an off system, which we do have, and I have those numbers of the eligible students, and they are being populated to the system. But we have been in training with DPI so that we can ensure that students are not uploaded to the system, because it could potentially reduce our ADA if a child stops coming in, have not met their 45 hours or their 90 hours. So are they in 21 DC today? Not totally, but they are available to be put into 21 DC with the instructions that we've been given over the past couple months through last week from DPI. We have an off system monitoring that will allow us to put them in according to what we've been instructed to do.
All right. Well, let me ask Ms. Brigman then, from the department standpoint and overseeing this, from the department standpoint, what is the status of cohort 15 in terms of where the ADA and the progress being made sits right now, right at this time?
Okay, as Zach pointed out, Vice Chair, there is not enough data that has been entered into the system for Maggie's outreach at this point in this fiscal year for us to make a determination. And I do want to provide some clarity around the 45 hours and not entering that into the system. That is a program decision to do that. DPI has informed the grantees that you develop your own attendance reporting policies and procedures as to when you want to enter data into the system. If you are concerned about not meeting ADA and things of that nature, if you want to wait until 45 hours to enter the students into the system, that is your prerogative. But I do want to make sure that everyone understands that that is not a requirement issued by us. We let programs know that you should be looking at your attendance policies to make sure that students that are being entered into the system are truly attending your program regularly, because once a student is entered into the 21 DC system, due to U.S. Department of Ed regulations, those students cannot be removed from the system. They remain in your system the entire year because U.S. Department of Ed, whether the students have attended 1 hour or 45 or 90 hours, they want every student captured in that system. And so they leave it up to the state's discretion. We can advise our grantees to enter the data if they have 20 hours. Some grantees wait until students have 20 hours. But I would like to make the point that it is December the 5th, and if there are no students that are at 45 hours yet, that would be a little concerning to me. Because if you've been in operation since October, 1st of October, I would assume that the majority of your students would have 45 hours of programming by December.
All right. Well, in the interest of fairness, is there a response to those concerns that have been expressed by the department?
Thank you, Chair. Go ahead.
Yes, and I am a little baffled in the total response. However, in our tracker that we do have, and the staff is currently scheduled, we have over 48 of the 60 that are enrolled that have more than 45 hours, to ensure that we were not combated with students reducing our ADA that did not make that did not have the 45 hours, which is the guidance we have received, and those guidance are recorded, that we would take other precautions to be able to eliminate low ADAs. This is the guidance we're receiving. This is what we've been doing. However, I have no worries about the 60 children, that students that are currently enrolled, and that we can upload this data as we speak with those children meeting the 45 hours for eligibility.
Ms. Brigman, I assume you would like that information uploaded now so that you would have, by now, I mean, obviously today, tomorrow, whenever it can quickly be loaded up, so that you can have an opportunity to review and analyze it. Is that fair?
Sure, that's fine.
All right. So do you have, back back to Mr. Coker, if I could, are there plans, if the board allows for, to go forward with programming this spring, which would be the end of cohort 15?
Chair Duncan, you breaking up a little bit. I apologize. We're getting feedback. You said something about plans for the spring?
Are there plans, that is, are there any actions that have been taken to go forward through the spring semester with a cohort 15 or not?
Yes.
And are there any signups already in place or not yet?
Yes, our goal, the grant goals is that all the students up through 80 are there through the end of the program year. And just to say that our grant also has a summer piece, and we're planning that. That's in our continuation application that we've submitted and returned back with comments, and also submitted our budget amendment to go along with that. Definitely for cohort 15, we're planning to go through the entire program year through September. If continuous funding is allotted, if the program is not terminated, we thought we were on a good track with 15. Just today, finding out that it was up for termination is a little alarming, because it was said that it was settled. However, the answer to your question is that we are fully committed to taking this program, cohort 15, throughout the duration of what it was funded to do.
And to be clear, it's not settled till the state board takes a vote, whatever that vote might be. Did you hear that?
Yes.
Okay, thank you.
So it's not settled.
Right.
Okay.
Clarify that.
Okay.
So let's go on to cohort 16 if we can. And I'll express for myself, I don't know if my colleagues share this concern. I'm very concerned about having less than 2 students in a cohort for 50 with the number of dollars that are allocated to it. And so I need to hear, I'm going to open the floor, but I will say I need to be persuaded as to why that is cohort 16 should not be terminated, because it does not appear to be on any form of trajectory for success for students. And so I need to hear whatever you'd like to say about that.
So I do agree that our numbers were low, and they were low because for several reasons. One is that when we received our initial letter to cease all of our programs, we had over 130 children enrolled in cohort 14 and 15 at the time. The nonprofit took the position to utilize its funds to maintain all of those 7 school sites to run. Cohort 16, the first year we got started in that cohort late because of this initial approval. And in 2 months after we got started, we had the monitoring in January. Enrollment for high schoolers are very difficult, not realizing that. I did discuss, and I had a conversation, is can we add 8th graders or 1 grade from the middle school, because enrollment was difficult. Staffing without dollars was difficult during that time. I do not negate the fact that we did not meet that target. However, we only received 1 draw. We did not receive the 400,000. And I asked that this year, we be given an opportunity to demonstrate the same level of service to our high schoolers, our 8th graders. In our continuation application, we asked for an amendment to add 8th graders. We are getting a lot of support to enroll 8th graders, and we've been out in the community collaborating with our district. We do not intend, and I had no disagreement with the fact that we had to put in for a funding reduction. No, we did not meet it. Our district needs this program, and I would like the opportunity, without the fact that we were back and forth with all of the other logistics of the monitoring, be removed from the opportunity that will allow us to really effectively serve. You're correct. It is hard to swallow, and we did not receive $400,000. However, what we were able to do and what we can do now is the same level of programming in our district that DPI has allowed us to do since 2016. And we have effectively worked in our district and continuously providing services. We've added and we're continues to add. I humbly submit to all of you, I make no excuses for the fact that we did not meet our target. And that has been addressed and the dollars have been taken back for that year. But what I have done and what we've done and what this organization continues to do in this community is meet the needs of our families and our children. And I would ask that we would be given that if additional monitoring needs to be done as far as the training. We are not training, as Ms. Brickman said, I am in every meeting. I am on every site. I understand the law. I do, and I understand what we needed to do. We could not successfully do that. And I'm not trying to hide behind that. All I'm asking is that you could allow us to demonstrate the same effectiveness that we've done all these years. That's what I've asked. Chair, you're muted. Chair, you're muted.
Thank you.
Chair, could I ask a question?
Please.
Are you the only after-school program in your district?
We're the only one providing free after school to our students, yes, district-wide.
So, and are you in middle schools? You are in middle schools?
We're in elementary, middle, and high.
But not much, not many folks in high school are going to take advantage of after school, and I understand that. That is not a criticism, that's just the reality.
We found that.
Yeah.
All right. Wendell, do you have any questions right here?
No, Mr. Chairman, thank you.
All right. I want to offer the department, if anyone wants to follow up with any comments after the comments we just received from Ms. Ray.
Well, I have quite a bit to say about, as a part of our rebuttal, Mr. Chair. Would you like to hear that now or specifically to those comments?
I didn't know if, for example, Ms. Brigman had any immediate response. And if not, that's fine. And we'll just move to rebuttal.
Well, I think we have quite a bit, but I would just note the one, to the extent that even though we haven't been able to identify those numbers, 25 students is not sufficient to qualify for this grant. So I think the statement was made by Ms. Ray that for cohort 16, they now have 25 enrolled students. That's half of what is required. To the extent that's true, would be the only comment. I have other things to say about cohort 16, but I'll reserve that.
All right. So why don't we move then to rebuttal? Unless there's any other questions, why don't we move to rebuttal? We've probably used a little more time than 15 minutes for each. I know both of you were relatively brief, but we did have a number of questions for things that need to be asked. Is 5 minutes rebuttal enough, or do you need 7?
I'll shoot for 5. I'll do my best.
If you need 7, you can have them, but let's max out at 7 if we can.
Okay. I mean, I think the first thing I have quite a bit that I want to respond to that Mr. Coker said. But I want to make clear first and foremost, this is a reimbursement grant. So the contention that they gave back this money is simply not true. They didn't receive it. What happened was, and I found it interesting because Ms. Coker read through the policies, that's exactly what DPI did. Last year, when they went through the second round in order to qualify for the second installment of this grant, as we've talked about the regular attendance, they had to show 50% of their students was there for 45 hours. It was when they submitted that documentation that DPI became aware of the significant, and here I'm talking about cohort 16, significantly low number of students in that program. And that's what led to the December meeting to discuss the ADA, which is exactly what Mr. Coker read in the guidance. That's what occurred during that December meeting. And there were no steps taken. And so the idea that they gave back that money is simply incorrect. They just, they were only allowed to receive or be reimbursed for the $132,000, which I must note, they were reimbursed for the full $132,000 for 2 students. That was how that money was spent last year. $132,000 of public funds to serve 2 students. On many days, we've talked about for 1 student. And so, I mean, in regards to the fact that I think the reimbursement goes back to the hours and they weren't able to bring in those students. This again is a reimbursement grant. So if they didn't have the capabilities to have those students and then be reimbursed for them, then that cohort shouldn't exist. And I think that's been our position all along. And to the point I made a moment ago that they've made steps now to raise it to 25 purportedly enrolled students. That's still half of what's required as a minimum of enrolled students, not even talking about the daily attendance. We have no idea what those numbers are. So I think what got confusing and what Mr. Coker kind of jumped around with is that there were really 3 issues for Maggie's outreach. The first was the average daily attendance, specifically for cohort 16, which was first identified in December. Then the second and third arose in January when there was a fiscal review, and then also the CPMR, which was the comprehensive review. The fiscal review, which is what he referenced earlier in the letter of January 13th, and which was attached as one of our exhibits, identified $2,000, which had questionable funding, which led to the initial suspension of access. That money was returned by the agency, and then once that was, those issues were resolved, and then the programmatic issues were resolved. But the ADA never was, which has led to what is the underlying issue that's kind of undergirding our entire position here, which is why the actions were appropriate here, is that they never shown that they actually were satisfying the 70% for any of these cohorts, let alone 16, especially 16. I'm just trying to make sure that I cover the other things I wanted to say. I think Ms. Ray mentioned that when they received the letter to stop the funds, they moved them over to 14 and 15. That was in March. We're talking about January and February when they were serving 1 student and being reimbursed over $100,000 for that. I mean, so we're just talking about being good stewards of public funds. I don't think DPI acted correctly in cutting that off. I just want to make sure I've covered the other things. I think I've stated my position on the May 17th letter. I don't think we've changed that. I think that's been our position throughout the hearing when Ms. Jenkins made that same or similar argument. I think there were some safety concerns that arose, but I'll leave that as the chair, Mr. Chair. You noted that those weren't specifically stated in that letter, so I'm not going to delve into those too deeply. I think I just have to keep going back to, I think Ms. Ray mentioned the steps they've taken here, but specifically cohort 16, there are the students there to support that. We're talking about if they go back into receiving this, they're able to receive up to $400,000 for that grant. There are reasons why we required a certain number of kids that be riding these programs, because there's a set amount of funds that has to go to programs that are able to support it. We would be our positions. Maggie's outreach has not shown that in any way for cohort 16. And it would be our position as well for cohort 15. They still were 20% below what there was required there. We showed the numbers were provided that we sent in. They even said that they put all their funds to those 2 things. But for cohort 15, when you look at those numbers throughout that spring, well below. It wasn't close. It wasn't like they were required to be at 70% and they were at 65. They were at 50%. They're 20% below what was required day in and day out for that program, which doesn't necessitate that they should continue to receive hundreds of thousands of dollars in federal funds. So respectfully, I would just reiterate that it is our position that DPI complied with those guidance, which were read by Mr. Coker earlier, took the appropriate steps, and made the correct decision to terminate all 3 cohorts for Maggie's outreach.
All right, thank you very much.
Thank you, sir.
Yes, Mr. Coker, let me allow you to have 7 minutes for rebuttal, up to 7 minutes for rebuttal if you need it.
Chair, what we would just simply say is that, first of all, we appreciate the panel taking the time to thoroughly review this matter and, ask the questions for clarification. As I can understand, looking at this record, there may be some questions, and so we appreciate that opportunity to clarify. What I would simply say is that, this is the state's second bite at the apple of trying to persuade the panel that Maggie's outreach failed to comply or should be terminated, the program should be terminated, and that they complied with all the rules and did not violate any of their own guidelines. But I think what it goes to show here is that both sides have issues. And I'm just being transparent. The state did not do what they were supposed to do in giving the technical training and also being clear in what the requirements were. And Maggie's outreach, unfortunately, relied on the information from the state, but more importantly, attempted to do what they were supposed to do. And here in particular, what I would say is just that, cohort 16 is what it is. And I mean, the numbers are what they are, but as to 14, 15, Maggie's outreach definitely was in compliance in those situations. And so my whole thing in this particular case is that we have guidelines that the state has in place that is put in place to make sure and to ensure that programs like Maggie's Outreach has an opportunity before termination to attempt to get the technical assistance to work it out. And the system failed everywhere here for whatever reason. They weren't given the technical assistance. The state didn't comply with what the requirements were that they were supposed to do. And the outcome is where we are today with the situation of a hot mess. And the thing that we have here, though, is we have Miss Ray and her program who, had the intestinal fortitude to continue to operate in order to provide the needs to those in Hope County so that they would not be denied the benefits and the programs that have been offered by the state and operators such as Maggie's Outreach. And so what we would ask is that this panel, again, in its review, look at the facts in this case and what they are, and apply the rules and the guidance that have been provided. And I think the panel would come to the same logical conclusion that the hearing officer did. And so that's what we would ask. And Ms. Ray wanted to just make one point.
I wanted to add to Attorney Staton, Paget, I'm sorry. I wanted to comment on cohort 15. Cohort 15, who was funded to serve 80 children, served and enrolled 102. Although all of those children did not meet the ADA for reasons, we're in a military town, so, and there were all different circumstances that caused that. We exceeded the enrollment. While the ADA was a factor, it is not the only factor that is outlined in your guidance package, your Exhibit 3 8.C program attendance. There are 3 components there, and you must consider all 3 to come to a ruling that ADA is the only outline that would say that we were not in compliance with our assurance document. December 9th, as I want to reiterate to you, the state did not come to our office to provide training on ADA. The state brought out its new guidance document. We had started our program in October. On December 9th, it issued the 22-23 guidance. Ms. Locklear, the state representative, came to our office to provide training on the document, not on ADA and not technical assistance. And so I just want to make those things, while they sound good, those are not the actual facts. We're here to serve these children. We're here to handle and manage all of the compliance, and with no other reason to do the best job we can in this county. And so I cannot today fight ADA because there's too many components that led to low ADA than what you're outlining in your rebuttal and in the state statement. Those factors are not the only factors. And so I wanted to leave with that today and humbly submit to all of you a decision that will continue to allow the children and families in Hope County to receive the services that these dollars is intended to provide. We're providing them. And if you can see by our newspaper, you can call everyone in our county. We are doing that. I can't fight you on your ADA, but I can tell you that we're providing the services that this grant outlines, and we're in compliance and doing everything that we have been required to do and have done that since 2016. And so that is the position of our organization. I thank our attorney for representing us in here, but as the owner and the day-to-day worker, we're doing our job. I can't fight you on ADA.
All right, well, thank you very much. I really do want to stop and thank our participants, the council, Mr. Coker, council, Mr. Patch. Thank you for your presentations and your written product as well, which were helpful to the panel for an understanding of the issues in this case. I want to thank Ms. Ray and thank Ms. Brigman for your comments to provide further factual background for the panel in order to get an understanding from the perspectives of the parties in terms of trying to get a full picture of where we were. So thank you for your patience with the panel going through this and the information you provided. At this time, the panel will now proceed to deliberate and vote on a recommended decision. The vote must be by roll call, and I would note that if any member of the panel desires to receive any legal advice, it's necessary to make a motion to go into closed session pursuant to GS 115C-318.11A3 for purposes of if you need to or feel the need to get some legal advice before we deliberate or during the deliberation, either one. So let me pause now and ask, is there any member of the panel who would like to make a request to go to closed session for purposes only of receiving any legal advice with respect to what we've heard?
Vice Chair Duncan, I would we move into closed session so we can get legal advice.
All right, and that would be pursuant to GS 115C-318.11A3, I assume.
Yes, sir. Thank you.
All right. We'll need a roll call back vote on that motion.
Mr. Blackburn,
Yes.
Mr. Duncan,
Yes.
Mr. Hall,
Yes.
All right, we will now go into closed session. Technically, could you explain, Rupen, what that means for the people who we're going to go about this technologically so everyone knows how to stand by?
Yes, sir. And so we're going to ask that everyone leave the WebEx so that we can hold the closed session here using this link. Vice Chair, we typically give them a time when we would return. And so do you want to go into closed session and ask everyone to come back in a set amount of time?
Let me ask my colleagues, Mr. Blackburn, Mr. Hall, do you think stay 4:35, roughly 10 minutes in closed session will be sufficient to get your inquiries responded to?
10
I
minutes.
agree.
Yes, thank you.
Okay, very good. So I think that answers the question. We would want everybody to join back in at 4:35.
Okay, thank you, everyone. Vice Chair Duncan,
Yeah.
we are live.
Very good. Do we have everybody back?
Looks like it.
It appears so.
All right. Well, then let us, with respect to deliberations, let me call on Mr. Blackburn for any comments he might have.
I want to thank the folks at Maggie's Outreach for their fine work that they're doing and hope that they'll continue to do the fine work that they're doing in this county.
All right, thank you.
Thank you.
Mr. Hall, do you have any comments?
No, sir. Thank you, Mr. Chairman.
All right, well, I'm going to propose a motion for your consideration and do with it as you may want, including amending it or whatever. But I'm going to propose a motion that we recommend to the State Board of Education to make a modified recommendation from the decision of the hearing officer, which would make the following determinations. First, that the 2023 cohort has been closed and is therefore moot, as the panel understands it. The 2024 cohort should be allowed to proceed forward with the understanding that it will be striving to, if not the panel would and board would hope, would reach 70% of the students attending to complete successfully the work of that program, and would ask as part of that there be technical assistance provided by the department to assist Maggie's outreach to help reach those goals on behalf of our students. And third, would propose that the cohort 16, which has had issues for almost a year at this point in terms of not being able to have the number of students in attendance or signed up for that program, and has in fact been very much below the recommended numbers for the program, that at this point that cohort, that is cohort 16, be terminated at this point. So I make those recommendations and throw them out for comment, or I make that recommendation as a motion and throw it out for comment to my fellow members of the panel.
Mr. Chair, I'll second your motion.
All right, thank you. Mr. Hall, any comments?
No, sir. Thank you, Mr. Chairman.
All right, thank you. Are there any other motions that anyone cares to make, or should we proceed to vote on this motion?
I call the question.
All right, very good. We'll turn, Ruben, if we can turn to you to please call the roll at this point.
Mr. Blackburn,
Yes.
Mr. Duncan,
Yes.
Mr. Hall.
Yes.
All right, that motion passes by way of a recommendation to the full board unanimously. This item will be up for discussion at the State Board of Education meeting during the course of the Business Operations Committee presentation tomorrow, December 6, 2023. That portion of the meeting is not till the afternoon, just for those interested. And a final decision will be made by the board at its December 7th, 2023 meeting, when votes are taken on all items. The State Board of Education meeting is a meeting you can attend at the Education Building in Raleigh, or alternatively, if you desire, you can stream live using the YouTube link found on the State Board's website. Again, I want to reiterate our thanks to all the participants in this hearing for your contributions and very much helpful nature of those contributions for the board to get a good the board panel to get a good understanding of all the issues. So at this point, I ask for a motion and a second to adjourn.
So move.
Second.
All right.
Mr. Blackburn,
Yes.
Mr. Duncan,
Yes.
Mr. Hall.
Yes.
All right, very good. At this point, with great thanks to all the people involved here for this, arranging this meeting, we stand adjourned. Thank you all.
Thank you.